Okay, I think we can start. Welcome everybody to this webinar today. It's my pleasure to have you all here, my panelists, and also everybody that took the time to join to listen to them. I'd like to introduce myself to start. My name is Gilson. I'm the co-founder and CEO of VAF Compliance, a fully fledged compliance out of Dubai. The purpose of this webinar today is to explore regulatory aspects, challenge, and best practices associated with the travel rule globally, and more specifically in the UAE. Again, like I said, I'm delighted to be joined today by 4 industry experts that I'll allow them to say a few words, introduce themselves, Samir, Soham, Arm, and Andrew. So maybe, Samir, if you could say a few words to start, please.
Yes, thank you all for having me and welcome everyone attending. I am the head of FinTech and AI at the law firm Baker McKenzie International, head of FinTech and AI for the Middle East. My core practice area is financial regulation, financial crime, sanctions from a public policy perspective, private advisory perspective, and an investigations perspective. And I come from a background of both law and computer science as well.
Thank you so much, Samir, for that. Soham?
All right, thank you. I'm Harm, I'm co-founder of 21 Analytics. We are a technology solution provider for all things travel rule and self-hosted wallet verification or unhosted wallet verification. We are a Swiss company founded a couple of years ago. And we have a mission to make cryptocurrencies succeed in the world. And in order to do so, we are alleviating the pain that the travel rule brings. Happy to be here today. Looking forward to it.
Thank you so much for coming. Soham?
Hi guys, my name is Soham Panchmia. I'm a lawyer. I work at Reed Smith in the Dubai and Abu Dhabi offices. I have been in the crypto space primarily as a coder since my university days, which was a long time ago. I still code, although if someone asked me to code in Soul, I just give up. Also Ton now. That's even worse than Soul. I didn't think that was possible. Anyway, I do a lot of the licensing stuff, which Gilson can tell you all about. But it's working with the regulators here in the UAE or with the MAS in Singapore or with the HKM and the SFC in Hong Kong or the regulators across Europe and the UK and America. We kind of do all of it. My practice is split between the regulatory questions, i.e., is my business going to result in the government knocking on my door and should I be worried about it? That's where I come in to help you structure your business or to structure your token or to structure your overall model to either make sure that doesn't happen or to make sure you get your licenses if we can't avoid it. And on the flip side, the other half of my practice is pure disputes. I run a lot of cryptocurrency-based arbitrations and court cases, primarily arbitrations, sometimes against centralized exchanges, sometimes for them, sometimes against DEXs, and sometimes when crypto companies decide to eat each other, and then sometimes when investors decide to sue their portfolio companies because they've refused to give them the tokens that were promised in the VAFs. Mostly that. So yeah, just a little bit about me and happy to be here.
Thank you. Andrew?
Yeah, thanks. Thanks, everybody. Really, really glad to be here. My name is Andrew Kimbrough. I'm currently working on building out the compliance program for a DeFi aggregator called 1inch Network. They're moving into the regulated space. Prior to that, I was the head of compliance at for a crypto bank based in Switzerland, where we struggle a lot with this topic, what we're going to talk about today, travel rule, and all the other things around crypto. It's not an easy space to be in, definitely. Before that, I got into crypto around 5 years ago in the compliance space. Got originally into compliance in 2008 in the financial services area, and I've been in regulated finance for about 20 years now.
Thank you so much, everybody, for those kind of introductions. I would like to start, let's say, for the basics. So actually understanding the travel rule and really taking it back to its, I guess, origin, back to FATF recommendation 16. So I guess maybe what I would like to hear maybe from some of our panelists, and maybe perhaps I can start with you, Samir, a little bit around this recommendation, and I guess how can we define the travel rule and its origin?
So essentially, the way to think about it is from a conventional banking perspective, and then we sort of apply and see how that applies to crypto. So in the traditional finance space, when you send transactions from one party to another, that typically goes through the SWIFT system, although there are alternatives. And there are a number of, there's a payload of information that is required under existing law to be transferred from the originator to the beneficiary. And that is used for a number of reasons, primarily for the combating of financial crime, money laundering, counterterrorism financing. With regards to crypto, following the FATF recommendation 16 that you mentioned, the travel rule is essentially the crypto equivalent of that. And the primary concerns cited, and you will most likely all sort of AML related issues, not limited to the travel rule, but all AML issues that are compliance issues are often cited for crypto, like the travel rule, often come from a perspective of combating financial crime. And of course, there is evidence that terrorism financing and other illegal and illicit trade is facilitated through crypto. I would say that, generally speaking, sure, crypto does play an element of it, but so does the existing financial world. So I think sometimes crypto gets a bad rep for being the facilitator because of certain aspects, anonymity, etc. But essentially, look, the FATF, which for those who don't know, stands for the Financial Action Task Force. It's a Paris-based organization that have countries as its members, or have regional bodies where countries are members of regional bodies, and then those regional bodies are members. But essentially, it's a country membership kind of or pan country membership regime, where they have come up with 40 recommendations. 40 recommendations about what every legal and regulatory framework needs to have in order to have an effective anti-money laundering, counterterrorism financing regime. And they review countries typically on a 10-year basis in what's called a mutual evaluation report, or an MER. And based on that, I'm sure there are subsequent reviews in between, a country will have a sort of a risk rating on whether they are largely compliant, partially compliant, non-compliant, or compliant with the various 40 recommendations. And it should be noted that the travel rule is just one of, or even a sub-element of one of those recommendations with regards to crypto. I'll let the others speak as well at this point, but I think what I would love to come back to at some point is, where does the travel rule within crypto and AML, where does that sit? For whom? For VASPs, virtual asset service providers, but for other entities or participants that need to engage with VASPs, and even for third parties that help to facilitate the cross-border transactional activity between VASPs. So I'll let the others chime in at this point, but would love to talk about the whole system holistically.
For sure.
And just talk specifically about UAE regulation.
Sure, and I think you touch in a very good point that definitely I want to touch on, also on the key components of the travel rule. As an example, the customer information and the responsibilities of service providers or VASPs as well. So maybe we could get I would like to hear everyone's opinion on this, but perhaps we could go to Harm that has a more technical perspective on this. It would be interesting to see how he sees this part.
Yeah, Samir, I'm quite impressed how you put this in words, because that was perfect. So from a technical perspective, this is obviously very different from the fiat world. It's to a degree quite a bit harder to do. where in the fiat world there's Swift, other networks too, but I think that Swift being the dominant network here. And with crypto, there is no such method. And this is basically the reason why we got involved. I have an engineering background as well, and we saw this recommendation 16 being published. And that I'm not even sure how it came to my desk, but I saw this and it was like, okay, this gives reason for pause, because as Soham probably can acknowledge, you are going to need to exchange messages between two entities. And how are you going to do this? It is on the face of it, it's pretty simple. Right, you need to collect the beneficiary information. You probably already, or you should already have the originator information, and you just package this up and send it off. But this now becomes a machine-to-machine communication. How are you going to do this? So what we saw, especially very much in the beginning, 3 years ago, there was an explosion of different solutions, of the different options out there. And I think Andrew can attest, because in Switzerland the travel rule was very early on enforced, and then you need to do this as a VASP, but who's on the other end, right? This is cross-jurisdictional, so Switzerland needs to adhere to the travel rule, but you're sending coins to I don't know, the Netherlands, for example. That's where I'm from, and all of a sudden you need to get this message, whatever that is. You need to get that message to the other side. That's what the travel rule states. You need to send this message in a secure and instant manner. How are you going to do this? So the devil is very much in these details, and I think what the Swiss have done is actually quite interesting, because they were beholden to the travel rule. And what most Swiss VASP said, we are not going to transfer your coins to another VASP, because that's what travel rule is, right? It's a VASP to another VASP. So if you don't do a transfer to another VASP, you don't need to comply with the travel rule. That, of course, opens up another avenue, because then the user will come at you and say, yes, this address really is my my self-hosted wallet, or unhosted wallet, or non-custodial wallet. You see a lot of terms there. But then you need to prove that this actually is the case, because if the user is lying or is making a mistake, you need to explain that to your regulator. So there are a couple of ways of doing that, and I think again Switzerland made the sensible choice in that case. I think it was even SEBA who was doing this at some point, doing something called a Satoshi test, where the user needs to send a small amount to an address controlled by a VASP, and then you whitelist this address. So my point here is that on the face value, it's very simple. Just gather this data and send it over. But as soon as you start to implement it, it will balloon out of control. There's even in the space, there are terms for this. So you have the sunrise issue. I'm sure some of the audience are familiar with this issue. The sunrise issue, what you need to be compliant, but your counterparty is not. How are you going to deal with that? But also the VASP discovery problem. So your user gets at your door and says, I want to withdraw coins to this address. To whom does that address belong? You don't know. You need to discover that.
Yes.
And that's tricky.
I think that you made some really good points, and I think actually it will be good then maybe perhaps before you actually give Soham's opinion, because Soham also has this experience across different jurisdictions, to hear a little bit more about Andrew, because obviously you have this use case scenario from an operation perspective, from a compliance perspective, how I guess you will define it on its origin, the travel rule itself.
Yeah, exactly. I mean, it's actually a good lead in from what Harm was talking about. From practical perspective, if we go back to the original question, why are we collecting this information? It is for anti-money laundering purposes. It is specifically to be able to effectively file suspicious activity reports, or SARs, which is part of what if you're familiar with banking at all, this is a pretty common activity. You see a client who is conducting has certain types of transactions that look suspicious. then there is a report template that you need to complete and file and send to your local authority that's responsible for that. Now, so you can basically there's a way for doing that within the fiat space. The information you have to exchange and collect is there, and so you can put that package together. You send it to the authorities. In the crypto space, yes, you can come up with ways to exchange that information, but as Harm was saying, oftentimes you're not exchanging information between regulated entities. It's not a VASP to the VASP. It's not a bank to a VASP. It is a VASP to an unhosted wallet, for example. So there is no intermediary there, which creates that additional problem of, okay, you have this, you have an exchange with an unhosted wallet, and you say that's my client's unhosted wallet. They have a hosted wallet with me as a VASP, but they also have this unhosted one that they had to exchange with me. How do I know that they actually control it, that it's theirs? And so as Harm was talking about, there's the Satoshi test, or it's basically a crypto micropayment, which is the basis upon which you say, okay, you establish control. So when they're in crypto, there's in addition to collecting that information, from the originator to the beneficiary, you have to establish who controls a wallet. And that can be a very tricky thing to do, because you can say, okay, you do it once. Okay, well, how long is that wallet whitelisted for? How long can you say that person still controls it? Depends on your regulator. Can even depend on each individual VASP and how the regulator treats them. For example, in the previous role that I was at, if you look at SEBA, if you look at Signum, the Swiss banks, there was basically a 2-week period that the regulator allowed us to say that's whitelisted. But it's different in different jurisdictions. There's also one, it can be risk appetite based. Some firms say, nope, 2 weeks, a month, I don't care. It needs to be done every single time there's a transaction with me. So there's no consistency. It's not written down in the regulation. And so it creates a headache for all of us in the space. So if you're doing it if you're doing it day to day, if you have to do this as a practitioner, the key is write down in a procedure what it is exactly you do and how you do it. What is that whitelisting period? Define it all. And then either A, take that to your regulator if you are in a jurisdiction where you can do that, and you can in Switzerland and in the UAE. You can talk to them about these type of topics, and you can say, is that acceptable? Or bar that, make sure that you have a good law firm that does have connections to the regulator that can give you the kind of feedback that you need, so you can feel confident that you are, at least in principle, following the travel rule.
If I can just respond to one or two things that Andrew mentioned. So, for example, what you mentioned, Andrew, in terms of the Satoshi tests, this is stuff that the conventional fiat world have had equivalents with for a long time. I remember when I had to open a PayPal account, but I don't know if PayPal still requires this, but there was like a £1 transaction split into two, and I had to go to my ATM or see my statement and then enter those in. And then now when we have mobile and digital banking, we have a number of different OTC related provisions. And I think, I saw somebody in the audience ask already about the sunrise test or the sunrise issue, and just for the avoidance of doubt, the sunrise issue is where your regulator requires a compliance with the travel rule, but you're potentially doing transactions with other jurisdictions where they don't have that requirement. Now, I've been focusing on financial regulation in the UAE and in the wider Middle East for 10 years across sanctions and all these different areas, working with regulators across licensing, conduct issues. And when I look at compliance, I look at it from other areas of compliance that we can potentially see either what we can learn from or see where the path is heading. If you take sanctions, for example, you can be a UAE-based bank with no US ownership or control. But because of commercial reality, forget about the law that applies to you, commercial reality to allow you to have US dollar clearing or US dollar access through a US dollar clearing bank, typically those agreements will say you have to comply with US OFAC sanctions. OFAC, So I probably a similar approach is how, from a little, not from a legal perspective, but from a commercial reality perspective, it's going to have to, I think that will be something to address the sunrise issue more sooner than some would think.
So, is there something like that?
Yeah, no. So I've done a fair amount of sanction. I think every law firm across the world in the past 2 years since the war has done a tremendous amount of sanctions work. But I appreciate Samir is specialist in it, so I won't dare to try and say anything contrary to that. What I would say is, having lived with the crypto regulations day in and day out, first when I was practicing in Singapore and now here in the UAE, there isn't much equivalence in the way financial services regulations are being utilized for crypto as they are for TradFi. I think Harm, Andrew, Waleed, all of you have worked in banks that have had a crypto equivalent, and you've seen the difference in the way the regulators treat us. And this isn't necessarily because what we're doing is so fantastically different. Samir is absolutely right. Equivalents of the Satoshi tests and measures have existed in TradFi for a long time. It's the fundamental matter is regulators are scared, and they're scared because they don't understand it, and because they're so poorly staffed with underpaid employees who are usually fresh graduates from university, that by the time someone begins to understand what's happening, they've quit and they've gone in-house to work for someone like me or Samir, and we poach them. So that's the fundamental problem. I mean, that's the problem we've seen round and round in the MAS. We have clients that have been waiting for 3 years for CMS licenses in virtual asset space, and they've had 6 caseworkers in 3 years. Every 6 months, a new 22-year-old National University of Singapore graduate becomes their new caseworker. So it's not necessarily a problem of how they're understanding the regulations. The problem is the regulators themselves are not able to get themselves around it. We've had multiple conversations. I think Gilson can speak to this as well. It's very rare in most jurisdictions to find a regulator who A, understands crypto, and B, after understanding it, is forthright enough to take a position on it. I think in the UAE, we're quite spoiled in that. You have places like people like Peter Liu and Malcolm Wright Vara. You've got Brian Bayagabi and Brian Yeo in the FSRA, who are taking very bold stances and are willing to speak about crypto in a very open and transparent way. And you can have conversations with them about, well, these are our policies about the travel rule. This is how much our tech, or how far our tech is willing to go or able to go to help deal with this question. However, we're not dealing with certain kinds of VASPs on the other side, so we don't necessarily have the sunrise issue. The fundamental way in which we've gotten around dealing with the sunrise issue is not an answer that most companies appreciate, but it's frankly that when you're dealing with counterparties in jurisdictions that don't have the travel rule, and you're in a jurisdiction where that is an issue, then you have to comply with the de minimis requirements. So under VARA, that's, I think, 3,500 dirhams. FATF regs require anything above 1,000 euros to have to comply. So, I mean, it basically is everything. So if you're in a jurisdiction that doesn't abide by it, you basically put an iron curtain up and you don't deal with that jurisdiction. Some companies set up 2 structures. One is the regulated structure, one is the unregulated structure. And I'm sure anybody who's attending this right now is avidly following the drama that's happening in the US SEC proceedings against Binance. And that will give you a front row seat of what happens when you separate out your regulated entities with your unregulated entities to do as you will. So it's a slight period of uncertainty, and new rules have to be developed using the old rules and adapting them in a more efficient way. And mostly we need regulators to not be scared.
Yeah, no, I would totally agree that I think that progress or technology, unfortunately or fortunately, comes first before regulators, and then they always need to catch up. I wanted to continue on the same component, going perhaps a little bit more inside or to key elements of the travel rule itself, because I think it comes in line with what you're just saying, such as the required customer information responsibilities that VASPs have with the travel rule itself. So perhaps maybe we could even continue with you. So perhaps in terms, what are the key components that someone that wants to actually comply with the travel rule, and I just mentioned customer information being one of them, that a VASP needs, or someone that, or interacting with a VASP needs to collect?
Right. So primarily there's about A, B, C in the FATF guidelines. You've got to look at specifically your own regulators' rules about which part of the guidelines have been adopted formally and which haven't. So I'll speak about the UAE position as a control. So if you look at the VAR regulations in the compliance rulebook, they've taken what we consider the FATF-B, which is the main issue, the one that Harm was discussing earlier, which is that you need to collect your originator information, you need to collect your beneficiary information, and you need to know who is the originator sending what to the beneficiary. And that information needs to be collected and recorded and made available for review to the regulator as part of your, annualized report that gets put together at the end of a reporting period. Now, that's all very well and easy to put down in a couple of paragraphs in the compliance rulebook, but it's, as Harm explained in quite a lot of detail, it's very, very difficult to achieve from a tech perspective when the beneficiary on the other side might be an unhosted wallet that is just a serial number and has, by design, no identity information associated with it. And what that's doing is, the solution right now has been, as we're dealing with crypto companies, dealing with licensing, not only in this part of the world, but in any part of the world, is there's a divide. There are those that are willing to deal in KYC AML circles, and then there are those that are not. And those that are not are finding it increasingly difficult to find jurisdictions in order to house their platforms. You know, previously it was BVI and Cayman all the way. That was the traditional structure. Everybody was obsessed with it. And now we're seeing increasingly more fruity jurisdictions coming into the play. You know, we're having discussions about St. Vincent and the Grenadines and Seychelles and Panama a lot more than we did in 2018 or 2019. That's because even VASP laws have come into the BVI and Cayman, because they've all understood the risk that comes with the CFT component of not mandating KYC with crypto transactions. So the solution is segregation.
Okay.
Yeah, and if I may add a little bit to that, I think it was Samir who used the term commercial reality. I very much like that, because the Trevor rule is in that sense contagious. So you as an entity might be living in the Seychelles or something like that, but you still want to do business, right? And that means that the other end of your business relationship might be in the European Union or in Dubai, and then you just need to be beholden to the Trevor rule. That's it. Otherwise, this transaction is just going to be bounced back at you. So the commercial reality is, to steal that word yet again, is that this is happening. This is happening. There is no, I really do believe that there's no fleeing this, and the regulator is wisening up to certain things. I remember 3 years ago when I learned about the screenshotting. I think I'm addressing Mr. Velstad's question here. Screenshotting of addresses was accepted. So the user would just send a screenshot of their wallet to say that that this is theirs. This is obviously ludicrous, and regulators are catching up. Regulators are wisening up. They know what the possibilities now are. We mentioned the Satoshi test, but with crypto, you actually have several methods of enhancing that even further. I think somebody in the chat also mentioned like bots trading and all that stuff. You can do this instantly, quickly with just cryptographic message signing, for example. So I think the regulators are talking to each other. We as 21 Analytics, we frequent the VCG work groups with the VAF, and they are very keen to learn. There is some knowledge gap there, what is possible, but I do believe that this knowledge gap is going to be closed in the coming years. So that's I think a good thing, and Trevor rule is contagious in that sense. And even further, so there is a limit of 3.5K, I think, in Dubai. The limit in the EU, for example, is 0. The FATF said 1,000. I think everybody in the end will default to 0. Collect everything, send everything. That's not a reality which I'm overly keen on, but otherwise, the business reality is that that you're going to you're simplifying your business structure in that sense.
Right.
You have less things to do.
I want to, I guess, on the back of that, and because we're talking about harmonization, I guess, and how this is going to be possible, right? I want to talk a little bit about, of course, we talk about some nuances already, discuss maybe, Samir, you can address this one, potential penalties and consequences of non-compliance with the travel rule. Being such, obviously now we have MiCA as well in Europe, right? That perhaps just due to the large amount of countries that will adopt that stance, will, I guess, enforce or force their position on other countries, on other jurisdictions that interact with them. So be interesting to hear a little bit more about that and penalties and consequences for non-compliance. And maybe after something, maybe Andrew could also add something. You're on mute.
Sorry, I think after we discuss penalties and other connected areas like cybersecurity and data protection, I would love to hear the panel's views on the interoperability issues of the different of different travel rules solutions. And on one side, it's great that it's a free market with so many solutions, and we can talk about a few of the main ones, but how will they all connect? Whether we explore financial APIs like we see in open banking, it will be an interesting one. And you mentioned, Harm, about the screenshotting issue. This is, by the way, something that was already within open banking, initially accepted and later prohibited under relevant legislation. Well, they call it screen scraping, right? So this is, I think when we look at these issues, always useful as a thinker and planner to see what's the next steps and how to bridge gaps is to explore how it's been done in sort of similar areas as well. Well, on the penalties point, I would say two things in the UAE. From an AML perspective, we have a federal AML law that applies equally in the DI. So maybe just backtrack for a second. The UAE, for those who don't know, is a federation of 7 emirates. It follows a civil law regime. It's a federal system. Within one of those emirates, the Emirate of Dubai, you have the DIFC. It's the Dubai International Financial Center. That is a financial free zone. It has its own civil and commercial laws and its separate regulator, financial regulator, which is also looking at VASPs within the DIFC. Similarly, in Abu Dhabi, there is the ADGM, established in 2013-14, and that's another financial free zone, the Abu Dhabi Global Market. It has its own financial regulator, the FSRA, Financial Service Regulatory Authority, and it's a very similar approach in terms of being common law based and having its separate regime. The area in between is often referred to as onshore UAE. And within onshore UAE, we have 2 regulators. We have the Central Bank of the UAE, and relevant to this conversation is payment tokens. They do cover payment services providers, and they under their purview would be stablecoin and payment tokens potentially. And we have a federal securities sector regulator, which is also the federal VASP regulator. That's called the SCA, Security and Commodities Authority. It gets a little bit more complicated in Dubai because we have that extra complexity of if it's not a security token, then we have a separate regulator for Dubai other than in the DIFC. And this is, we've mentioned it several times in the call, and that's VARA, the Virtual Assets Regulatory Authority. The world's first dedicated virtual or VASP sector regulator. And as Soham mentioned, the likes of David and Malcolm there are, good examples of how you have industry specialists and industry expertise who are at the regulators table, or in that they're leading the charge with good industry knowledge. In light of all that, there is a federal AML law in the UAE, and that law was amended in 2001 to extend to VASPs. Before, it only applied to financial institutions. There's another category called DNFPPs. I won't get into that, but essentially it's law firms, accounting firms, etc. And it was extended to VASPs. So the entire ambit, the entire spectrum of AML-related obligations. KYC, client due diligence, enhanced due diligence, if there are any potential high-risk issues or red flags, risk assessment across the different categories of assets and subcategories of assets relevant to this conversation, different maybe risk assessments depending on the different protocols behind the various virtual assets used, are things that must be done, including having policies. Failing to do these things, and I would argue that the travel rule, although not in name, but it does fall under this sort of this parameter. If a money laundering offense is conducted in the UAE, the penalties under the federal are wide, from 200,000 to 5 million dirhams. And of course, if it's an AML offense, there's potential imprisonment. The issue about this particular sanction is, to prove a money laundering offense, you have to prove knowledge. So there are AML cases in the UAE, we see it, but that's usually something quite hard to prove. I'll move that to one side and I'll just talk about VARA, because when it comes to this area, you've got criminal, which is anti-money laundering criminal, which we've discussed, and that's hard to prove. But you also have civil penalties. So if you are regulated by VARA or the DFSA or the FSRA or any other financial regulator in the UAE or elsewhere in the world, your regulator will have the ability to impose civil fines and penalties on you. And for VARA, they separate it between compliance-related penalties and non-compliance-related penalties. So penalties under the compliance and risk framework, and for penalties that VARA can impose on a VASP, they are to disgorge any profits or losses avoided as a result of non-compliance, a penalty for individuals of up to 20 million dirhams. So that's, you know, on individuals themselves that work in VASPs. For the VASP themselves, a penalty potentially of up to 50 million dirhams, or 15% of the annual revenue, or 300% of the profits gained or losses avoided, whichever is greater. So of course, I don't believe, you know, I don't think for one particular small non-compliance of a travel rule that that's going to be the amount. It's just the regulator has the ability to, you know, go up to those numbers depending on the severity of
what they do, for sure. I wanted to move to the next one. I'm also cautious of time here, and something that I want to touch, and Samir touched on it as well. Perhaps we can hear a little bit from Andrew, and then from Arm as well, and of course Soham, in terms of what you touch, in terms of you know, challenges and solutions, right? What are the main challenges they face to the implementing? Technical complexities, right? Privacy concerns, and you mentioned interoperability between different platforms. Arm, of course, being one of the platforms that provides a solution. Andrew, what do you think are, in terms of privacy concerns, interoperability between different platforms that have come from different VASP, different regulations that want to implement the travel rule itself?
Sure. I mean, interoperability is definitely a very big issue on the crypto side. You know, whereas you have you know, local clearing systems country by country, whereas you have SWIFT for cross-border payments, you know, it's one system that everyone uses that operates in that space. So if you're a regulated VASP, if you're a bank, if you're a broker dealer, whatever. On the crypto side, there is no central system like that. So you have to have some kind of you know, you'll have your own procedure around, okay, here's the information that I have to collect if someone sends me a crypto payment. Here's what I'm going to send if there's a crypto payment. Maybe you have some kind of a mechanism for doing that, you know, whether it's a secure email or whatever. But will it work with the recipient or whoever's sending it to you? Maybe, maybe not. So in effect, what you have to do is go out and establish bilaterally, you know, as a VASP, you say, okay, the way that we've approached in the past, say, okay, who are going to be the main players that we will be interacting with in this regard, and then we'll establish with them, a procedure. Here's what we'll exchange, and here's how we'll exchange it. It is obviously it's clunky. It's not going to be the same for every one of your partner VASPs, but it's something that works. Of course, the downside is, a new VASP comes in and wants to transact with you one time, you're probably going to turn them down. You can't afford to have the gap in your compliance program where you say, well, we'll accept this one transaction from this one VASP without sufficient information or outside of our own procedure, and take a bet on, hey, will our auditor find out or not? I mean, the fact is they probably will. So in that regard, yes, it is a problem. It is something that different organizations in different countries and regions are working on, establishing some kind of a standard whereby you can plug into something like a SWIFT for crypto to exchange the information in addition to executing the transaction. But for the time being, it's just, as an individual VASP, you're on your own. You need to prioritize your business commercially, and then determine, okay, where is it worth spending my time establishing these bilateral relationships?
Harm, it would be interesting to hear from your side, being a solution provider in the industry. How do you address this?
Yeah, so this is exactly why we are a technology solution provider. We support several of these methods, and there are many different solutions out there. You hear about TRP, you hear about trust. And then there are a lot of other solutions out there. Our solution supports several of them, but there is actually quite an easy way to get started with all of this. So, well, if you read the FATF travel rule closely, you need to securely and immediately send the information to the counterparty. That can be, as Andrew mentioned, an encrypted email. Actually, the encrypted part of the email might or might not be required, depending a little bit on your risk appetite, but you can just email them. So that means that at that point, you've collected the information, you sent the email, and you store and hold that information and can turn it over to the regulator. At that point, you have complied with the travel rule. What your counterparty is doing with that email is up to them. The other way around is a little bit trickier. As Andrew again pointed out neatly, there is one transaction coming in. What are you going to do with that? You need to have these supports and standards. And what we're championing with our solution, or actually with anybody really, open up an email address, travel address at myvasp.com. Make sure that everybody knows about this address, and then you can receive this information. If you just receive that information, then you at least did step one right. And what our solution, for example, is doing, we have an AI reading this email box. We take this unstructured data, make sure that it's complete, and insert it into a database so you can have easy access and easy overview of all the stuff in there. In my darker days, I think that's probably how it's going to work for a long time. This is the sunrise issue. Somebody in the audience asked this as well. How are you going to address this? I think email is the way to address this. Exchange, publish your travel rule at compliance, your travel rule at email address. Then you at least have something done. This is also about the relationship you're having with your regulator. You need to get the ball rolling, and it's easy to get going in this way. It is, you still need to collect this data, but now you can send it out and you can receive it, and now you can at least keep your business going. Because don't get me wrong, if you need to comply with the travel rule, there is no such thing as just I'm going to accept this transfer and now deal with it later. No, this is not how it's happening. You can only credit these coins to your customer if you have all this data. So this is a hard blocker. You need to fix this. And I think that's oftentimes when I talk to VASP, this is a bit of a shock to them. Apparently, this is not evident, and this is very imperative. And it's easy to get going. publish this email address, get in contact with a technology service provider as us. We are very keen to helping you doing this, and it's to get to this. Somebody asked about IoT things. So in the end, you want this automated as much as possible, but I think the reality of the fact is that we're in this sunrise period. This sunrise period is going to last some time. I don't believe there is going to be one solution which is going to rule them all. I think privacy was mentioned earlier on. If you do business with Trust, for example, then that's one of these travel rule networks you plug in. But that means that Trust, which is owned by Coinbase, now knows how much volume you're doing, how much transactions you're doing. That might or might not be fine, but you need to think about that. You need to step back and think about what that means for your business. I speak to a lot of European and South Asian VASPs. They don't want this. They want something else. So be cognizant of the issues you're running into this. As I mentioned, travel rule is deceptively simple if you look at it, but it escalates in lots. It touches your organization at every level.
Before we, and again, conscious of time here, thank you so much for that. Samir and Soham, would you like to add just a few more pointers on this one, if you can, before we answer some of the questions from our participants before we close the.
Sure. Harm picked up the point that I would raise as sort of the biggest concern. The travel rule and the way it gets interpreted and applied is challenging, but that's something for consultants, lawyers, and solutions providers to work out and create solutions for. To me, the biggest problem I see in the industry is, I've already talked about how difficult it is dealing with regulators. I think anybody who's had any exposure to the space will tell you whether or not they're in crypto, actually dealing with regulators is challenging. For me, the biggest challenge is having VASPs level up. They are all willing to park money aside for their marketing, for their operations, for their extremely expensive tech teams, which all justified costs. None of them are willing to spend any money on internally organizing themselves. They consider it to be irrelevant. And what they don't understand is this is not the world we were in 2018 or 2017 or 2019. That laissez-faire degen attitude of I'm just going to bootleg something on Discord server with 6 of my mates from around the world. Like, you can try, you're not going to get very far with it unless you choose to operate purely on the dark web. And even then, like it happened with, it's a far off example, but like it happened with streaming services, right? I mean, 10 years ago, everybody was illegally pirating content. Today, we all rather just pay that $5, $10, get a streaming service and get a seamless service that we know we're not going to get into trouble for. That's what's going to happen to crypto in the next 5 years, which is when you get so many licensed players becoming available on the market, the unlicensed ones are going to find it harder and harder to operate. And basically all the pure degens who genuinely want to hide something will end up with them. So in order to level up and deal with regulators, the first thing is put aside some of your fundraising budget, whatever you fundraise, either increase it by 10 or 15 or 20% and create an operational budget to organize yourself internally. Don't be afraid to hire top quality consultants or lawyers or advisors or whatever it is. Don't go asking people to be advisors on your board and then ignore everything they advise you to do.
This is the cost of doing business, guys.
Yeah.
You need to comply.
So just start there, and honestly the rest of the process will actually get a lot easier. They've just got to decide that they want to attack the problem head on, and the regulators are happy to deal with them. They've just got to come forward with a plan, because the regulators, they're there to just make sure your plan works. They're not there to create a plan for you, which is often the problem we face with a lot of VASPs.
Absolutely, and I think that's a very good point you make, and we see this even now with some applications to Vara, where you're expecting the regulator to be giving you the answers. Be like, no, that's not that job.
You want
Samir, can you ask?
Yeah, it's a good job. Just a few small bullet points, and then my concluding thoughts. So, for anyone looking at this space in terms of getting a sense about, what's happening globally, the different initiatives, there are some open initiatives. You've got InterVASP. That's just sort of a technical standard for what the messaging content, what the information payload should include and in what format. There are other initiatives like Open VASP, led by Bitcoin Suisse, who are looking at discovering and developing a directory of sorts, and Bit75, and of course Generation 21 and different private sector initiatives. The other point that we didn't really discuss, which I'd like to just mention, is cybersecurity. We talked about data protection and needing to comply with UAE data protection law and potentially GDPR and how that works. And I would say there are many solutions about how it works in open banking and in other fintech related fields. Those are already a lot of lessons learned there. On cybersecurity, VARA, if you are a VASP, VARA does have a technology and information rulebook, and it provides sort of tech governance and different things there that can apply. In the UAE, you have the UAE Information Assurance Standards, which is a bit more stringent than ISO 27001. The UAE has a very strong focus on cyber security. My concluding thoughts, following the great points made by Soham and the other panelists. I'm a firm advocate that within fintech and within crypto and within virtual assets, there are two roles to be played here. Number one, if you are a startup or growth stage or even big tech, focusing on good governance and compliance on this issue and on many other issues. Related party transactions is a famous one following FTX, but on so many different issues. And even if your activity doesn't actually technically fall under a regulator framework, behaving like a regulated entity, sure, you want to have someone to report to, but good governance and good compliance is going to do a few things. It's going to build trust in the market. It's going to add it's going to limit liability, whether that's a claim or a dispute with a user or a shareholder or investor or a regulator if you're getting direct enforcement action against you. And it's going to allow you to be interconnected, like we discussed with earlier on. If you don't have certain things, compliance mechanisms in place, you just, in some cases, like in Korea, there was a case, and in the UAE is the case, you will just have the curtain pulled up and you won't be able to do cross-border transactions with that jurisdiction. Having those things for value creation will allow you to have a better, I think lights have gone off in this room, but will allow you to have value creation for being a more attractive business, and allow you to attract more investment as being a more safer pair of hands. And I would say two things on the other side. For VCs investing into this space, being active shareholder, being an activist shareholder in pushing and propagating and requiring your portfolio companies to have, an agenda trajectory towards good governance and compliance is how you as a VC are going to get that 10x, 20x, and hopefully create the incubate, properly incubate, not just financially, but properly incubate the unicorns of tomorrow. And how you as a VC are also going to look out for the interests of your own investors who may come from more conservative, risk appetites. So, yeah, those are my thoughts.
Thank you so much. I think we have time to get final quick comments from the other panelists, just on lessons learned. And I guess if you could, practical tips for our webinars attendees to enhance their own compliance efforts, such as Samir just mentioned. Maybe we can start with you, Andrew, then go to Soham, and then Arm. Thank you.
Sure. No, I'll try to be brief on this. So yeah, the formula is understand the regulations and how they apply to you. Have your own policies and procedures in place that dictate how you as an organization are going to handle these regulations, whether it's travel rule, whether it's conflicts of interest, whatever it is. Make sure that you're following those policies and procedures. and establish a good working relationship with your regulator. As I think it was, as Samir was saying, you can approach these guys. I mean, there is a learning curve going on right now in the industry, both the regulators and with commercial entities, where we are all learning how this works, and we are all learning what are the right types of procedures to follow. What kind of technology should we use? So by having that open exchange, you also establish yourself as a credible player in the regulated VAF space, and you will also get a lot more goodwill from the regulator.
Thank you. So Ham?
I just leave with one thought for anybody running a VASP and trying to figure out if the regulations are something they should be worried about. This is a question we often get from crypto derivative creators, structured products creators that use virtual assets, as well as DeFi platforms. I always say, here's the fundamental question you need to ask yourself. When you look at your business model, can you answer the question, am I telling people, whoever people may be, your customers, to trust me with their money? If you are telling people to trust you with their money, you're going to get regulated in some way, shape, or form. And if your answer is, I have a smart contract and I'm telling them to trust the smart contract, well, then if the answer is, if you coded that smart contract and you own the proprietary code to it, and you can go in and change the code to it if something goes wrong, then you're still telling people to trust you with their money, even if it's sitting in a smart contract. So just saying you have a smart contract automating things doesn't make you DeFi. Actually, ceding control completely to a community makes you DeFi. And if you don't have a community, you're a DeFi in waiting. So trust me with your money. If that is your tagline, you need to get regulated, and you will.
DeFi waiting. I love that. Harm?
Yeah, it is a big field. Lots of things need to happen, but there are very tangible first steps you can take. Get this email address out there. Figure out who your counterparties are. Are these reputable? Get a grip on that. Yeah, look at your organization. What is your risk appetite? Are you comfortable storing all your PII data at a SaaS solution, or do you want to be compliant with all the privacy regulation, and do you want to keep this in-house? Because the travel rule information, I think we sort of touched on that. It's very privacy sensitive, not only for you as a business, but also what your clients. You're sending financial transaction information across the wire. So, and I think that's the reasoning why you need to do your KYV, your know your VASP, know your counterparty, do a CDD on that. And be cognizant of where you store this data. These are very simple questions you can start answering on Monday, and then you at least started to get the ball rolling. And you need to get the ball rolling now.
I was going to say thank you so much. I think that we barely scraped it. I think we could stay here talking for another hour. So maybe we'll do a part 2 at some stage.
That sounds good.
Yeah, I think there was a lot of more topics we could have continue to talk. I think there were some great questions that we will try to address after the webinar. I just want to say thank you to everyone that joined the webinar today. Thank you to our panelists that took some time off their busy day schedule to help us understand a little bit more about the travel rule. And stay focused. We'll try to do more informative sessions with quality players in the industry itself. And I wish you all a great day, whatever is ahead, depending where you are in the world. Thank you so much, guys. Take care. All the best. Thank you.
Yeah. Cheers.
Cheers.